Of the interim committee on the judiciary to order. And would our clerk please call the roll?
Senator Berg, Senator Carroll, Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers, Senator Storm, Senator Turner, Senator Wheeler, Representative Banta.
Here.
Representative Blanton. Here. Representative Bratcher.
Here.
Representative Bray.
Here.
Representative Burke. Representative Decker. Representative Dietz.
Present.
Representative Flannery.
Here.
Representative Herron. Representative Kulkarni.
Present.
Representative Lewis.
Present.
Representative Maddox. Representative Mosier.
Here.
Representative Nemes. Representative Petrie.
Here.
Representative Rawlings.
Here.
Representative Sharp.
Present.
Representative Stevenson. Representative Wilson. Co-Chair Westerfield. Co-Chair Elliott.
I'm here. So first of all, I would like to introduce our new members on the committee. We have Senator Matthew Deneen, Senator Brandon Storm, Representative Josh Bray, Representative Lindsey Burke, Representative Stephanie Dietz, Representative Keturah Herron, Representative Steve Rawlings, Representative Scott Sharp, and Representative Nick Wilson. So we're so happy to and pleased to have each of those individuals with us on the committee, obviously in the session, but now in the interim as well. Our first item on the agenda is the Controlled Substances and Homicide discussion, and that was House Bill 388 from the session. And if Representative Deanna Frazier Gordon and Representative John Blanton would come forward with their guests and introduce themselves for the record, and then you can proceed. Thank you.
Thank you, Chairman and members of the committee. I appreciate you hearing this bill today. And this was something that we filed last year just to kind of get the conversation started, and so I'm glad to be able to discuss it in greater detail. I have guests from the City of Richmond Police Department as well as my co-sponsor, Representative Blanton. But this is something that my constituents have been asking us for, and probably yours as well. We're not making good progress in the issues of opioid abuse and drug trafficking, and 20 other states in some way have enhanced their charges dealing in this area, and so they're here to just kind of discuss what's happening in Madison County and to see how we want to address it in the General Assembly. Yeah, so just introduce yourself.
Thank you. My name's Rodney Richardson. I'm the Chief of Police at the Richmond Police Department in Madison County. First, I'd like to say thanks for having me today. It's one of my first opportunities to address a committee, so this is a big moment for me, and I appreciate the time that you are taking to hear this. We are in crisis mode in Madison County, specifically the city of Richmond, and when it comes to the fatality rate for overdoses, the city of Richmond is kind of the leader in Madison County. And I'm going to throw a few numbers at you just so you understand what we're dealing with. But in Madison County in 2021, we had 85 overdose fatalities. In 2020, we had 68. The city of Richmond alone in 2021 had 48 of those. And in 2022, we had 50, nearly one every week. Now, that's one a week that our officers have to respond to, one a week where we're finding people that are deceased, either in their homes, in parking lots, in cars, in tents on the side of the road, wherever we can find them. These are the ones that are reported to us. So mind you, when I give you these numbers, these are numbers that maybe sometimes we may not get a number of someone that goes to the hospital who spends 3 or 4 days and then passes away. So with those numbers in mind, What started our response and how we've kind of been doing it at the police department, in 2019, there was a group of mothers that had called and wanted to speak to me, and they were pretty upset with the way the department was handling overdose cases. Now, this was new to us. In 2019, we hadn't seen the numbers like we'd seen in the past, and we assumed that some of the overdose numbers that we were seeing were kind of almost like the ones that we'd saw in the past with methadone and Xanax and various drugs that were being mixed. But fentanyl kind of took us, and the derivatives of fentanyl, and it took us to a new era, a place we didn't think we would be at. And the mothers basically wanted to know what law enforcement was doing with the individuals that sold their baby girl or baby boy this narcotic that caused their death. And lucky enough, in 2019, the Kentucky General Assembly changed the law, which gave us something that we could charge them with, which was manslaughter. Manslaughter in the second degree, which is a non-violent felony offense. But what that requires is some type of payment that we have to prove. Remuneration is what the actual statute says. Now, that's pretty difficult to prove sometimes. The only thing we have going for us is a lot of people do business on Cash App. They'll do a lot of business on social media. And sometimes, luckily, if we can gather a victim's cell phone, we might be able to get that sort of information. But when we explain to a parent, to a mother or a father, that we can only charge the suspect that sold their child either something they might have thought was heroin or some type of prescription medication with manslaughter, and that the offense could carry 5 to 10 years at max, but this being a first offense, we didn't know how it was going to be. And of course, you know, when the law changes and there's new cases that come before the court, there's lessons to be learned. There's interpretations. So we've worked through a lot of that. Currently now we have about 15 individuals that we've charged with manslaughter to the second degree, and only 2 have pled guilty to that, and the rest have either been dismissed or they're still pending. Parents are upset, and I can only imagine, I have a small child, but I can only imagine how the parents feel when we tell them that the individual that caused their baby's death can only be charged with manslaughter and not murder. They just can't comprehend why it's any different. So as you can imagine, I am in very much support of 388. We have to do something. Law enforcement has to have a tool in order to charge these individuals to hopefully put a stop to what we're seeing on the streets of Richmond. And I've asked my commander of support services, Major Josh Hale, to come with me today. And Major Hale is over the support side, which is all of our non-sworn employees, all of our detectives, narcotics investigations, task forces. And he has a lot of direct contact with family members, moms and dads, when they come to the police department. And they're mad at law enforcement. They're angry that we're not doing more, that we can't charge more. But I asked him to come to speak to you today to kind of give you a little insight of what some of these parents and maybe some of these family members have to say when they meet with us. So thank you very much.
Well, good morning. As Chief Richardson said, my name is Major Josh Hale. I am the Support Services Commander for the Richmond Police Department. Thank you also for having me. This is also my first time speaking before a committee like this, so I'm thankful and grateful for the opportunity to do so. I wish it was under better circumstances, but I do hope that we can come to some resolution for why we are here and to some good purpose for why we are here. I am also in support of House Bill 388. I come to you more from the, I guess, the humanistic side of things. As Chief Richardson said, I do supervise for the Richmond Police Department all the task forces and the detectives and all the personnel that are the ones that overall deal with these overdose deaths and work these investigations. to walk you through what an overdose death investigation will look like, I'll just paint the picture for you because I think that's very important for you to have that. Patrol officer will get the call. We get the call through 911 or through our non-emergency number, and this is just the Richmond Police Department, so I can't speak for other agencies, but I would suspect it's very similar to other agencies. The Richmond Police Department will get the call through our dispatch center in Madison County. Patrol will respond. We will find a deceased individual there. We will immediately begin an investigation there. We contact a supervisor. A supervisor will show up on scene. That is at the point when usually the coroner also shows up on scene. Loved ones will start arriving on scene. We have to keep the loved ones out of the scene. We have to make sure that the crime scene does not become contaminated so that we can further investigate properly what we need to do to make sure that we are not doing anything in an improper manner so that we can prosecute people as they, should we be able to find out if there is a suspect. Throughout this process, the detectives are called. They will show up on scene, and from there, an investigation will begin. The patrol officers, they are a part of this, but the detectives will then take over the investigation. Richmond Police Department is one of the first agencies throughout the Commonwealth of Kentucky to investigate overdose deaths as a homicide, or as a homicide investigation would be investigated. So we are looking for things that would be drug paraphernalia, cell phones, any information that would lead us to what caused the death of this individual. Meanwhile, the family is still standing outside a lot of times, or is at the hospital if they've gone to the hospital. The family is standing outside wanting answers. They sometimes are not waiting patiently. Many times are not waiting patiently. My detectives are still working vigorously. Put into perspective along with this, the challenge that law enforcement faces with personnel issues. Law enforcement is not getting the recruitment that we once had, and you don't have law enforcement having what they used to have for the law enforcement officers that would stay forever 20 years. And I think, Chief, you've been here for how many years now?
26.
26 years. So we don't get that. So you don't have that often as much anymore. So now we have personnel issues. So we face manpower issues also along with this. I have been through in 20 years, I've seen the changes in the drug culture to where now we went from marijuana and cocaine and crack cocaine to now we are dealing with multiple things like, of course, crystal methamphetamine, heroin, and fentanyl. And that is the majority of what we are now dealing with. And again, on these crime scenes, these families, they want answers. So when we investigate these things and we prosecute them, many times, again, either the prosecution is not able to, because of the law, prosecute, or because we're not able to prove with the manslaughter, we're not able to prove that the drug dealer provided this. So, House Bill 388 is something that would make it a little bit stronger. And again, with going back to the families, sometimes they even if we can convict, or even if they do plead guilty, that's still not enough. They want murder. They want, again, and I can never give an answer to a grieving mother or a grieving father when I don't have that. I can never bring a child back. I can never bring a father back. I can never bring a mother back. But what we can do is we can try our best to change the way we do business to where we can be more effective in the way we handle these drug dealers. I don't really know. I just kind of wanted to give that statement. I wanted to give the humanistic side of things. I wanted to paint that picture for you. I do open myself up to questions from you. If I can answer any questions, I would welcome that, because I want you to understand where we come from as detectives and as administrators trying to handle this problem. I want you to see from our perspective so that you can have that window into what law enforcement is facing in today's law enforcement culture.
Yes. Thank you, Mr. Chairman, members of the committee. Let me reiterate how important this tool is for our law enforcement communities to be able to investigate these crimes. Often we hear in the General Assembly from people, and we talk about that we want to be cautious because we want to go after the bad actors, but we want to get help for those that have problems. This is a tool to go after the bad actors. This is the tool to get off the street the people who are feeding this poison to our family, to our friends, to our neighbors, to have something that they can, with some teeth to it, that they could charge these individuals with. And quite frankly, I can go back to the 90s, and I wish personally that we'd had this statute back then, as there were multiple occasions during my days in special investigations we could have charged people with this statute, and it was unavailable. Now, there will be comments made says, well, this will cause people not to report overdose deaths because they're afraid of getting in trouble. Well, if you understand the law enforcement culture, you will find that if you're with somebody and they overdose and somebody else sold you the drugs, all you got to do is tell them where you got the drugs. We're not interested. They are not. I still refer to us as we. We're not interested in that user. We're interested in that dealer, the one that's putting the poison out on the street, the one that's killing our family members. And so this is another tool that will help law enforcement to get these people out of our communities and make it safer for our children, our neighbors, and our communities. So I encourage you all, when we get to session in January, that you be willing to support this, because every one of you all sitting here, every one of your communities are impacted by the drug problem. Every one of us. And this is just another tool to be able to help our law enforcement in this battle against these drugs. Thank you all.
Thank you very much, and there is some discussion. Representative Decker is recognized.
Thank you. I appreciate you representatives for bringing this bill, and officers for the work you do and for being here today. I have a simple question, partially answered, I think. You said 15 have been charged, only 2 have been found guilty. The rest have been dismissed or pending. How many have been dismissed of that 15?
In 2020, we charged 4. 2 were found guilty. 1 was failure to indict. 1 was dismissed. In 2021, we charged 6 individuals. 3 were dismissed. 3 are still pending. In 2022, we charged 5 individuals. 2 were dismissed, and 3 are still pending.
So 7 of the 15 were dismissed, and was it always on the grounds that you did not prove that they had actually supplied the narcotic?
No, not necessarily. No, ma'am. It could be for other reasons. The prosecutor may have some other reason why that they don't pursue it. It could be, as I stated earlier, a failure to indict on the grand jury side. This was new. You know, we had just started this, so we kind of were the first ones, like he said, to try it. So when we brought it to our court system, this was something new that they'd never seen before. And I knew there'd be some issues, but I do know that proving that payment was received is a tough one. And I've noticed that on some of our cases that, and I'll give you some examples. A girlfriend might give it to her boyfriend. Drug dealers use third parties now to drop off drugs. So you could make a drug transaction online, you can pay with a Cash App, and another individual can either deliver the drugs or they could be placed in a location where you come pick them up. So it can become difficult, and of course we don't have that individual to interview after it's occurred. We can only go on what we recover evidentiary, which is sometimes text messages, Facebook messages, and what's that stupid Snapchat? The Snapchat, thank you. Sorry, I didn't mean to call it. It causes us more problems than you know, but you got Snapchat and all these other social media devices that people use to communicate. So we really got, I mean, if we can have a case where I say, hey, Josh, would you bring me a gram of heroin for $40? And I say, yeah, I'll bring it to you. And then he texts me back and says, thanks for the $40. Be careful. That's some hot stuff. Hey, I haven't heard from you. Are you okay? Sometimes we get those type of messages. Unfortunately, those are good cases for us, but if we don't get it in that order, it could be difficult to prove.
Mr. Chairman, may I ask one more question?
Yes,
Thank
you may.
So this new proposal won't change that problem, right? You still will have to meet that burden, and so this is not a help in that regard in proving the cases.
I believe, ma'am, that the new proposal actually lists the word transfer. If there is a transfer, then that will solve that problem. Not just by receiving payment, but if I'm supplying you with the drug, that ends up causing your death. This new House Bill 388 is going to cover it.
So there was payment required last time.
It is. Remuneration is actually what's in manslaughter second, and that is basically just a payment of some sort.
Thank you, Mr. Chairman.
Yes, ma'am.
Thank you, Representative Bratcher.
I can remember being in this Judiciary Committee when Senator Webb was a representative and she was a freshman. She's not on this committee, I don't think. But that was a long time ago. It had to be like 1998, 99, something like that. And she was talking about how OxyContin was killing her district and her area. We've been talking about this stuff for 23 years at least. And here we are again, and guys come in and they say, this is the tools we need. And it's just like a revolving cycle of what needs to be done. And how much money, this is a rhetorical question, and I am coming to a question. How much money has the feds, the state, and local governments paid attacking this stuff? And is it doing any good? I mean, we have full-time staff that are fighting I think it's called the Drug Control Policy Forum or something. Are you seeing anything from them, or is that just a make a jobs program?
Sir, we do get a lot of stats from them. They supply us with stats. It helps me to know we have a great coroner in our county, and we work really well together. So I know what the ongoing stats is, but they do supply us with a lot of information in regards to what age group, the number of fentanyl versus methamphetamine, and county stats that we need to know. We're on an uptick, so it's told me basically that we're increasing our numbers. And right now, as of last weekend, we had two people that we found deceased from a drug overdose just over the weekend. So we're now at 22 individuals for 2023. So I expect that our numbers are going to be above 50.
One last question. I'm going to put the entire drug control enforcement on your shoulders right now and ask you this one question. Are we wasting our time each year down here? Or is this going to be the thing that does it?
Sir, I don't think we're ever going to be wasting time if we're talking about victims and families. And the reason I say that is because even if we were to look at the argument or the fact that someone would say that a drug user, whether you believe it's a disease or whether you believe it's a choice, that someone would choose to take the drugs themselves, the family members did not choose to have their family member pass away. So while we may be losing victims, we're losing victims, the family members didn't choose this. So as long as we are still fighting this, we're fighting for the victims' families. So no, I do not believe we're wasting the time nor the money.
But are you winning the fight?
I don't know that we'll ever win the fight, but I don't think it's ever one that we would stop fighting. Because I've seen all the children, and I haven't seen all the children, but I've dealt with lots of children. I've dealt with mothers and fathers and husbands and wives, and it goes on and on and on. And my detectives are called out at all hours of the night and all weekends and holidays. And so, no, I don't believe that we will ever, that's never a fight that we should stop. Never.
Let me respond to Representative Bratcher's question. Is this going to be the piece of legislation, the law that goes into effect, that's going to solve our problem? No. No. It's another tool. we're not going to arrest our way out of this problem, but it is a part of controlling and trying to bring things down, just as getting people into recovery centers and helping to get those mental health issues that they need to under control. But if we don't do and continue including the law enforcement side of things, can you imagine how out of control it would be? I mean, it's going to it would be unbelievable. It's already unbelievable, but the deaths are going to be too numerous to count. So if we take away, if you will, the fear of some type of punishment for these people that are dealing, then they're just going to go even more wide open, and they're going to be pushing it even harder, and we're going to see more and more drugs streaming in from South America and other countries that's killing our people. And so, no, this is not going to fix the problem, but it's certainly going to help, and it takes a multifaceted approach, and law enforcement is definitely part of that approach.
Representative Banta.
I like what you're trying to do. I just have a question. I'm not an attorney, but when I read this, it makes me wonder, when he or she unlawfully administers, if I give a prescription allergen medicine to somebody because they're having an allergy fit and they have a bad reaction, they die. I'm reading this. It seems like I would be prosecuted. No?
No, that's not correct. It says controlled substance, and allergy medicine is not a controlled substance.
Okay, a Vicodin. I think most people can relate to what I'm saying. You've got somebody, oh, I've got one of those, I'll give it to you.
Then by the language of this, it would be possible. I don't think it would be probable that somebody would prosecute you over something like that. This is about going after people who are drug dealers and would be utilized as such.
Just might be something to tighten up. I don't know.
It might, Representative, it might help a little bit to understand that in a situation, and I think I follow you. You're saying that if I wanted to help out a friend of mine and I gave them what I thought was Vicodin, but it ended up being fentanyl and it caused their death, is that what you're saying? Would they be prosecuted?
No, she's just
No.
saying, like, if I did have the Vicodin, I gave it to my family member because they overdosed. Yeah, and they
Oh,
overdosed.
okay.
Yeah.
Okay.
Representative Herron.
Thank you, Chairman. Thank you all for presenting on this important issue. I am a native of Madison County and a native of Richmond. I still have family who live there. And in 2019, one of my cousins was a part of that overdose number. And this morning, actually, on my way in, I spent time trying to reach someone from probation and parole, because I have another cousin who we fear that he potentially is going to be the next victim of an overdose. And so I get and understand the importance of this issue and the reason why we need to do things. But I am concerned about the increase in the charge. And so, for one, I think that Representative Bratcher spoke about the overdose numbers, and we just got a report this year from KIPRIC, the Kentucky Injury Prevention Research Center, that actually in Kentucky, in the past year, overdose deaths have decreased by 5%. And so one of my concerns is I'm not sure, well, I believe that the things that we have been doing as a state have obviously been assisting and helping. We do need to do some more things. So one of my questions is, of the folks that have been charged with the manslaughters at this point, do we know how many of those folks also had addiction issues?
I do not know that. And I would even, I wouldn't want to even guess, because I don't want to give you the wrong information, but I do not know. No.
And Mr. Chair, I have another question.
Yes, please.
The other question that I have is, do we know what those statewide numbers are as far as the number of law enforcement or courts who have attempted to use this manslaughter charge, and what those numbers are statewide?
Representative, I don't have those in front of me. I'm certain that those are probably attainable throughout the courts. That would be something we would have to actually probably do a little research on. We only pulled the ones for Madison County for us as we came here and spoke. But I will, just to answer your question a little bit further, thank you for your service to Madison County also. Happy to hear a Madison Countyan. One of the things that you were talking about being from Madison County, one of the concerns I have is that Kentucky has always been one of the leaders in law enforcement and leading the way in some of the things that we do. One of the concerns that I have, and one of the things that we see, especially my detectives, is that we see people coming in and setting up shops from other locations coming into Kentucky and setting up, and they're not being prosecuted as such, and then they can just go back home and act like nothing happened if that's the case, and they are free to go roam wherever they went or wherever they came from to go do whatever they did. So again, another reason for I am advocating for this is if they would like to come and reside in Kentucky, we can give them a reason to stay in Kentucky. That is one of the things I'm very strong for on that.
Thank you, and I agree. I mean, from the early '90s, I remember folks being from Detroit, coming to Richmond and living, and so I'm very familiar with that. And I do think that we need to continue to find some solutions. I'm just afraid that this may not be the solution. And the last time that I was in Richmond, I went to the teen center. And one of the things that the young people said is that we need to do more prevention and education for young people as it relates to drug abuse and addiction. And so I would like for us to think about what that looks like, not only in Richmond, but statewide, some type of, I don't know what it is, if it's more funding, campaigns for our youth. And so, again, thank you all for bringing this forward.
Representative Flannery.
I have some commentary and a two-part question. Representative Blanton and Representative Fraser Gordon, thank you all for bringing this. I generally agree with the concept on what you're trying to do here, because I believe that dope dealers that are peddling poison for profit and killing off our young people, you know, we need to have the tools in the toolbox to enact appropriate justice on them. So I absolutely agree with this. I have learned practicing law in different capacities that the intersection of addiction and the criminal justice system is complex and multifaceted. And sometimes the solutions aren't always as simple as we would like them to be. I do believe that we have gained ground, but this is always going to be an issue that we're going to have to tackle. So I think it's probably short-sighted to think that we're never going to have, crime in society or, lawlessness or some sort of, addiction problem. But I guess my question, two-part, is what is the narrative of the opposition to this proposed legislation, and who is really pushing that narrative?
We actually have DPA to give the narrative for the opposition, so you're free to answer, but that will be presented later on in the discussion, hopefully.
Herculean task as it may be.
Yeah, that's what I was just going to reiterate, that they are scheduled to speak in opposition, and I think that their narrative is that it just won't deter the activity.
Thank you.
Representative Burke, are you finished, sir? Okay, thank you. Representative Burke.
Thank you, Chairman. Thank you all so much for this proposal, because I agree with you and everyone in this room, I think, that drugs are a scourge on our communities. Within the last week, someone required 911 assistance in front of my home. They were asleep in their car and could not be roused. So this is every community. It's all across the state. These are our friends and our neighbors. They're people that we care about. my question is a simple one. You've mentioned that we already have the second-degree manslaughter statute, and that the problem with that statute is proving the remuneration, the payment that has occurred. Would that statute be a better tool if we simply struck the remuneration portion and said unlawful distribution of a Schedule I or Schedule II substance if that's the proximate cause of death?
Well, that would help us right now. I can't disagree with you there. But we need to have something a little stronger than a nonviolent offense, which, you know, they would be eligible to be released pretty soon. And I wouldn't want a mother or a family member to pass that individual on the street just a few years after or months after that occurred. So a first offense, Class C felony, and I don't have the exact numbers from the Department of Corrections, but they're not going to serve that entire length. That is a very short term, and I think we need something that would send a message to those individuals that are responsible for this, that Kentucky takes it seriously, and we're doing everything we can to put a stop to it.
May I ask a follow-up question, Chairman?
Yes, you may.
So, among this group of people, I'm one of the younger folks. I'm close to 40, so I'm not young by any means, but, you know, for us, I'm on the younger end. It hasn't been that long since I've had friends, classmates, people that I knew personally who I loved and saw go down the wrong path. Some of them made the U-turn they needed to make, and some of them did not make it out alive. And so when I think about the people who I knew and loved who were using and selling drugs, they were young people. They were young people who made big mistakes. They thought they were too cool. They thought that they would never experience the consequences of their actions. They thought they were going to live forever. So when I think about the people who are doing these things, yes, of course, some of them are these people from other places who have come to set up shop, and perhaps that tool is useful for them. But I wouldn't want that tool used against the 18 to 21-year-olds I knew who grew up here, who were from here, who had good parents here, who started to deal drugs to support their habit. You know, that they didn't get money from their parents to go buy drugs, so they found a way to use drugs, and that involved passing them along to their friends. So is there room for making changes in both of these statutes so that we aren't sending 18 to 21-year-olds who have a drug addiction problem to prison on a capital offense?
And I think for today's purposes, you know, this is something that we're beginning the discussion. And so all of the points that's been brought forward today, you know, we need to reconsider those. And I referenced earlier, Arkansas has a particularly good bill that is, they've titled it Death by Delivery, when they spell out some of the accomplice scenarios and that type of thing. And so, but still, from the point of the families, you know, there's really no age, sex, race. You know, this is about life and death, essentially. So, but I do understand your point, and it's unfortunate that people make bad decisions at any age.
And if I may respond to Representative
Yes,
Burke
go ahead.
On two things, because we do have several new members joining the committee, and for our audience to understand, when we say a nonviolent offense in Kentucky, although it may be a Class C and we hear 5 to 10 years, that doesn't mean they spend, let's say they get the minimum 5 years, they don't spend 5 years in prison, okay? In Kentucky, nonviolent, you become eligible for parole after 20%, not 85% like the federal system, 20% of your sentence is served, you become eligible for parole. So if you get a 5-year sentence, you become eligible for parole within 12 months. So let's understand that. It's not a full 5 years. And I understand what you're saying about the young folks, and, you know, but I also am one of these people that I don't ever want to forget the victim. You know, they may be 18, 19 years old, but if they're selling drugs, they're adults, you know, and if they're choosing, even to support their habit, they're selling drugs and it kills somebody else, there has to be accountability. We've gone away from that, and there has to be accountability for those people. I'm not saying we need to send them away for life, but we can't also forget about that family that's lost their loved one and that individual that died, and we have to find a balance there. Thank you.
Thank you. Do you think this bill adequately addresses the accomplice liability that I think you had referenced with the Arkansas statute? And I have read that, and it's a little bit more in depth with accomplice liability. And I know the officers discussed where a third party a lot of the times is used to transfer the drug to the victim.
Yes, thank you, Chairman, for the question. And I think we will need to look into some of those situations. Again, this was the bill draft that was filed last session, and it was just basically a conversation starter, and it was purposely written in a broad manner, so to be able to encompass a lot of these different situations and scenarios.
Okay, thank you. We have several more questions, but I do want to give DPA Scott West an opportunity to come forward and provide some commentary on the legislation.
Chair Elliott, thank you for allowing me to speak today.
You're welcome.
I appreciate it, and thank you, members, for listening. I want to start by saying that I do believe in the sincerity of the intent behind the bill. Representative Blanton's a friend of mine. I had the pleasure today of talking to Chief Richardson and Major Hale, and I have no doubt that what they want to do is to curb the scourge of overdose deaths that we have in this state. Having said that, I don't believe that 388, as it was numbered last year, does that, and for a variety of reasons. I did have sent a link to an article by the Drug Policy Alliance entitled "An Overdose Death is Not Murder, Why Drug-Induced Homicide Laws Are Counterproductive." And by counterproductive, they mean they're increasing the number of overdoses, not decreasing. And then if you find a link in that, and I did not print it out, I didn't have a stapler big enough to even staple the report. They cite to a report that was done and completed in 2017 that goes back almost a decade. And what they find is that it doesn't do anything to, the threat of worse prosecution doesn't do anything to stop the people who are selling this. But what it does do is it chills Good Samaritan laws. And there's a difference there. When you think about long-term consequences, many people act on in their crime without thinking of the long-term consequences. But the Good Samaritan, the one who's going to make a decision, they're dealing with an immediate consequence. Do I call now or do I not call now? And what this study finds is that the threat of criminal prosecution for murder or lesser degrees of murder are a chill effect and can actually leave in people walking away. Imagine, I had a child who recently graduated college, so I tend to think in terms of children now as college-aged, even though they're over 18. I get it. They're still children. And I think, okay, what if there's a party going on at UK or EKU or Western, and somebody brings a blunt or a marijuana joint to the party, and a child's going to try this for the first time. They don't know that somebody somewhere up the chain laced it with fentanyl. And they pass it. The person takes a drag. Nothing happens to that person. And that child passes it to another child. This time, the drag has a concentration of fentanyl in it, and the child falls over in overdose. Hopefully, somebody's going to call 911 and say, we have an overdose here, get to this child. I'm afraid that if it becomes widely known that you can be charged with murder, that's not going to happen. because murder is a tough charge. The child that passed it took a drag from one person and passed it, as 388 is written, is now chargeable with murder. 388 says that it's unlawful if you administer, deliver, distribute, or sell. We tend to think of the person upstream that's the mastermind behind this. If you want to use the word mastermind, I think it's a very weak-minded individual. But whoever it is that's decided they're going to make the big profit, whatever cartel or wannabe cartel who's trying to do this, they're up the stream. But the here and now is somebody who just gave somebody a marijuana cigarette and a person died. And the way 388 is written, that delivery of giving it to them is sufficient for them to be charged with murder. Which brings me to this point. There's no mens rea here. There's no level of culpability. The way 388 was written, it's a carve-out. You have subsection A in murder, which is intentional murder. I intend to kill you. And I do it, and I'm charged with intentional murder. Subsection B was aggravated wantonness. A person acts wantonly and with extreme disregard to the value of human life. That was subsection B. You could be charged with murder under either one of those. The way it's written, old B becomes C, and there's a new B, and it's absolute liability. It doesn't have a mens rea. In the hierarchy, we have intentional, we have knowing, we have wanton, that's aggravated, we have unaggravated wantonness, and we have reckless. This imposes the penalty of murder for someone who has less mental mens rea culpability than someone who we charge with reckless homicide. It's less than that. And so a person can be charged. If there's even-handed treatment of the law, then what you're going to see is the person who passes that marijuana doesn't have to know that it has fentanyl, doesn't have to intend anything. They're just passing the joint, and now they would be guilty of murder because the only thing this does is, was there a death? Did you deliver the drug? Doesn't matter what you knew, doesn't matter what you intended. That is amazing. To have a strict liability Class A felony would be unheard of. And then there's a pragmatic issue. I went and pulled the numbers, and they're awful. They're just terrible. There's 2,127 overdose deaths in Kentucky last year. I almost guarantee you that less than half of those were opened as a homicide. But they would be now. If you find a body in the street that has a bullet, you don't know who did it, you open a homicide investigation every time because you know this person died by a gunshot. You have to do a lot. Major Hale talked about how you open up investigation and all the legwork and footwork and resources that go into proving a murder. You know, I had two cousins, two first cousins, one in 2013, one in 2020, both died of an overdose. They were doing well. They had been through rehab. They were in recovery. And then trauma happened and relapse happened, and now they're gone. We don't know who gave them the drugs. What you would have, though, is 27 homicides opened. If you had even application of the law, and if you didn't have even application of the law, I heard my friend Representative Blanton say, well, that's not how the police operate. Well, number one, the kids who find themselves with somebody who just slumped over amidst them, they probably aren't going to know that. But even if that's the case, if we're saying we're not interested in prosecuting for murder these college students, we just want the person upstream, then you have passed a law that is not going to be given even-handed treatment. It's going to be, well, maybe in this instance, but not in this instance, depends on who you are. And we don't want to go there. The law should be even-handed application to everyone, and therefore it should be fair to everyone. And if we add the word transfer, which is another way of saying deliver, then what you're saying is anybody who passes something to someone else can be automatically, absolute liable for murder without having the slightest idea that what I just did is going to kill this person. And if we had another year like last year, it would be 27 homicides opened. that's going to be historical funding for the police. And then as they go to the court system, prosecutors, defense attorneys, judges, there's going to be a lot of that. This bill won't do what it's intended to do. It may well result in an increase as people quit calling. Our Good Samaritan law only protects you against 218A offenses. It does not protect you against other offenses outside 218A, and this would be outside of 218A. And so you may find a lessening of people willing to pick up the phone, call 911, and wait there till the police get there or the paramedics get there because they're afraid they're going to be charged with murder. And they could be. A police officer may elect not to, prosecutor may elect not to, but they could be. And then the only thing that has to be proven is this person died and you gave them the drug, no mens rea, less than reckless homicide. I ask you all, don't go there. It's not going to curb the number, it's going to increase the number. Thank you.
Thank you, Mr. West. And I know we had numerous other questions. We're not going to have time to get to those, but I'm hopeful that you will give those questions to staff or myself, and we'll get those to the appropriate parties. Thank you for your testimony. We're going to move on now to exoneration compensation, which is House Bill 571, Representative Jason Nemes. And if everyone would introduce themselves and
thank you, Mr.
you're
Chairman.
free to present.
Representative Jason Nemes from the 33rd House District, Jefferson, Oldham, Shelby counties.
Suzanne Hopp, Kentucky Innocence Project, Department of Public Advocacy, Directing Attorney.
BMX exoneree in Kentucky.
Make sure your microphone is on when you're speaking.
My name is Johnetta Carr. I'm an exoneree in Kentucky and an advocate for the wrongly convicted.
Mike Von Allman, wrongfully convicted.
Edwin Chandler, wrongfully convicted, advocate for compensation bill.
Mr. Chairman, thank you for calling this bill. I'll give a quick introduction and then pass it over to the experts in this area. But as I was driving, and thank you for allowing me to be called at this time. I was in Clark Circuit Court this morning while I was delayed. I was driving thinking about why is this bill so important to me? And Gerald, I think most important things we can learn as a child. I remember an anecdote when I was a little boy. I was throwing the ball against my house, and it bounced back and it hit the neighbor's window, Mr. Schneider's window. And my father, I didn't mean to hit it, but my father allowed me, he made me at the time, but I look back, he allowed me to not only pay for that window, but to help Mr. Schneider replace the window. I didn't do anything wrong. I was playing as a boy. I didn't intend to do it, but my father knew that lesson of me being accountable for my actions, even when they had a consequence that I didn't intend, was good for me, and it was good for Mr. Schneider. In this situation, this is not only good for the exoneree, who is actually innocent. It is also good for the state because it's important that we model the right type of behavior. And when the state makes a mistake, even unintentionally so, it is right, it is just that we put that we pay for in some way the consequences of our unintentional actions in some cases. So with that prologue, I will turn it over to people who are experts in this area. Thank you, Mr. Chairman.
And thank you for giving the Kentucky Innocence Project the opportunity to address this important issue. What we would like to preface everything with is the fact that Kentucky is only one of 12 states in the United States that does not have a wrongful conviction compensation bill. 38 states, as well as the District of Columbia and the federal government, compensate individuals that are wrongly convicted. And I think everybody here agrees a wrongful conviction is a tragedy, and folks assume that it ends when somebody's released. But that's really when Chapter 2 of our exonerees' tragic life, it opens into a second chapter for them. Because the toehold that most of us get after maybe 10 or 20 years of developing our education and our work experience and finding housing and buying a car and creating roots in a community, they've been stripped of that opportunity to do those things. So many of our exonerees spend not just a decade, but 2 decades or in excess of 2 decades in prison. And some of them go in when they're 30, 40 years old, and they're coming out of prison when they're 60 or 65 years old. And even the aunts and the uncles that knew them when they were younger, that were a part of their life, they've moved on. They've passed. They are not even available. Parents may be aging and are requiring assistance from their children, and they can't support their adult children. So we have exonerees literally who have walked out of prison with ailing health at age 60. Some of them didn't even survive long enough to be able to file suits and see civil suits advance in the federal courts, even when there was egregious behavior by the police and terrible conduct by local law enforcement. So we're here asking that Kentucky at least rise to the level what other 38 other states have done. And we're asking that House Bill 571 be considered as an important part of making our exonerees' lives whole again. So we've asked 3 of our exonerees to come and to address the committee and to talk a little bit about what life was like for them after they were released from prison. So I'd like to have Mr. Von Allman speak first.
Mr. Chairman, members of the committee, thank you for this opportunity to bring my story to you. To give you some span of my experience, in 1980, I voted for Ronald Reagan in hopes that he would get our hostages out of Iran. The next time I could vote, Barack Obama was in his 2nd term. Big, huge gap. I want to start by telling you that this bill doesn't cast any blame or point any fingers at any branch or entity of government. It is, however, an admission that government isn't flawless, and sometimes it creates great harm to its citizens. This bill is a reasonable compensation for the harm caused by a flaw in our government. My wrongful conviction started one night when this fellow went into a bar in South Louisville where he ended up abducting a young lady, took her to a local park where he raped her, robbed her, and sodomized her. The victim noticed the guy staring at her all night. She was able to put together this composite drawing, very accurate for this guy. The crime occurred on Friday night. Saturday night, this composite was circulated. Sunday night, this is me. I walked into the very same bar without a clue what was going on. But that resulted in a conviction and a sentence of 30 years. Right away, I started trying to prove my innocence. After a couple years of incarceration, I was able to get up to the Louisville Police Department, take a polygraph test, and my case was reopened again after 2 years. That reinvestigation never yielded anything of legal value, but after 11 years in my 4th meeting with the parole board gave me the benefit of the doubt and said, we're going to give you the benefit of the doubt, but don't go out there and make a mistake. We won't be as nice to you when you come back. I get out right away. I encounter the application process and the box. Check that box if you've been convicted of a felony. I knew I had to devise some kind of strategy around that box. Avoiding the box was it. But I felt some conviction in that, and I posed the question to my parole officer. Do I have to tell my employers that I am a convicted felon? He responded very angrily, and this was before the sex offense registry. Very angrily said, if you don't tell them that you're a convicted sex offender, I'm coming down there and telling myself. That started when I put in an application and would hand it to someone, and they would say, yes, can you start tomorrow? I would say, yes, but now I have to tell you, I am a convicted sex offender. One of the most difficult things you could imagine, to hand an application to some lady that you've never seen before, and she hire you, and then you got to tell her that information. Pretty difficult. The last application I put in using that strategy was a career decision as a plumber. I saw plumber's helpers in the newspaper, and I went and applied. I went through that process, got to where he hired me, and then told him that I was a convicted sex offender. He told me to be at this job site the next morning, where I was given a pick and a shovel and pointed at the hardest earth in Kentucky and said, we need a pipe to go from here to there, move that earth. For days, if not weeks, I picked and chiseled at that earth, trying to make that pipe able to go through there. They finally moved me over to another job and began to realize I was an asset for them. I found out later that from the office, well, the message was, work him so hard he quits. I didn't quit. I finally worked my way into an apprenticeship program and became successful as a plumber. 16 years elapsed. I pick up the newspaper one day and there's an article about the Kentucky Innocence Project, and I'm wondering, where did they come from and when did they start? I called them right away. They took my case and uncovered this textbook example of mistaken identity. This bill is only compensating a wrong. Many of you have already reviewed this situation and have already become co-sponsors to this bill. This is not a bill that should have any opposition. And if you disagree with that, I ask you to go back to your districts and ask any member of your district if they were jailed for 1 day wrongfully, should they be compensated? And then I ask you all to take those responses, come back, fully support this bill, sign on as a co-sponsor, and let's get it passed. Thank you.
Mr. Chair, thank you all for having us. My name is Edwin Chandler. I'm an exoneree from the state of Kentucky, Louisville, Kentucky. I served 8 years in prison, another 7 years on parole. I was exonerated in 2009. It was difficult to get employment after getting out of prison, being a convicted felon. And so once I was exonerated, I thought things would be a lot different for me in this situation, but it really wasn't. Just like Mr. Van Almen, I had hundreds of applications, several interviews that all ended up in the same facet. Mr. Chandler, unfortunately, we cannot employ you because of the nature of your crime. I had been convicted of a manslaughter and robbery. And so when I was released, I made parole, and so I had to serve another 7 years on parole as a criminal. But once my exoneration happened, I thought that those things would turn around. And so having this compensation bill, you have to understand that the jobs that we have to go and seek, we're not going to get those jobs. As being, a regular citizen, it's not going to happen that way. We have to have special attention for some of these things that we're going through, especially with the jobs. Like right now I have a nonprofit that services the aftercare for exonerees. It's called the Chandler Project. And so I put forth my own efforts and my own money to try and help combat what we go through as exonerees. Not just the employment, but the mental health that we all go through. I know myself, I suffer from a mild to severe case of PTSD. And so one day I was in my yard cutting grass, and this was right after my exoneration. And I was cutting my grass, and all of a sudden I just felt like I was back in prison. I felt like I could see the walls, I could see the fence, I could hear the keys, I could feel being in prison in this moment. And actually, I was having a blackout, and so this is just one of the hurdles that we have to go through and combat, not just employment, but on the mental side too. And as Susan had depicted, that a lot of the exonerees that get out, sometimes their age limit does not allow them to go back into a workforce. They've spent too much time in prison. And so then you don't have Social Security set up, you don't have anything for that individual. So that is where this bill comes into place at, is to compensate for all of the time that that wrongful conviction took up. And so along with Johnetta, and there's other exonerees in this room right now, we suffered a lot going through what we've been through, and I don't feel like we're really taking into accountability for what we've suffered. And so moving forward, I think this compensation bill helps do that. It helps bring those pieces together that are so far spread apart for us. We have to put so many things together just to live a normal life. So thank you.
Hello, is this my second time speaking here? I would like for you all to please, if you could, pay attention to the map that is on your screen. These are just some of the exonerees that are in Kentucky. Some of them are in the room sitting behind you right now. Some of them has passed away. And since this is my second time, like I said, speaking, if you all could just maybe research their cases, because it's important for their voices to be heard too. Honorable members of the Judiciary Committee. My name is Johnetta Carr, and I'm your constituent. I am here today to share with you my harrowing story of being wrongfully convicted and how the injustice has impacted my life. At 16 years old, I was taken to an interrogation room without parental consent for 11.5 hours for a crime I did not commit or have anything to do with. In an attempt to coerce a false confession out of me, I was verbally abused by the police. I maintained my innocence the entire time. I was immediately booked in juvenile detention where I sat innocently awaiting trial. I was young and I believed in the justice system and that eventually I would be proved innocent. On my 18th birthday, I was transferred to the jail where I sat close to another year and started giving up all hope that I could prove my innocence. Before trial, I was told I had to enter a plea or face the possibility of death. I was advised that by accepting an Alford plea, I would be maintaining my innocence. I ended up spending a total of 4 long unjust years in jails and prisons, also serving out 9 years on parole. In 2019, through the Kentucky Innocence Project, I became the youngest of 23 Kentuckians to be exonerated. The first known wrongful conviction in Kentucky dated back to 1988. William Virgil spent 28 years in prison for a crime he did not commit. He passed before getting a chance to see justice in Kentucky. The same year Mr. Vigil's wrongful conviction was the same year that I was born. Imagine that. Now imagine, if you will, for a minute, being ripped away from your family, your friends, hope, dreams, and everything familiar to you at the age of 16. The emotional and psychological toll of being wrongfully convicted cannot be overstated. When I left prison, I wanted desperately to support myself, but no one would give me a job. I had to sell plasma to earn money to help take care of myself, and I still have the plasma needle scar on my arm to remind me of just how scarce finding employment was upon my release. Being wrongly convicted stained my record. Even though I have been exonerated, I still bear the scars of the conviction. Being wrongly convicted is not something you can just ignore. After a while, you get used to the constant no's when filling out applications of basic needs for survival. Being wrongly convicted is a lifelong experience. The lack of acknowledgement and reparation for the wrongly convicted perpetrates a cycle of pain and suffering, making it difficult to move forward and reintegrate into society. By the strength and grace of God, family, friends, and people I have met along my journey, I'm able to sit before you today. I hope in sharing my living experiences and some of my hardships today, it serves as a reminder of how important and cogent this legislation is for Kentucky. Together, we can make a difference, ensuring that no innocent person suffers hardships long past their release from prison. No one should continue to suffer after having to endure the unimaginable. I'm striving for a system that upholds truth, fairness, and compassion, and that offers hope and a chance for redemption to those who have been wronged. I hope you would strive for this type of system too. Thank you.
So members of the committee, we're here to answer questions. I do believe that oftentimes when we've talked to individual legislatures, we've had specific questions about the number of exonerees that might be entitled to file something under the statute. First, we just want to say that it's not guaranteed that anybody would receive any kind of an award the way House Bill 571 is drafted, but that this just entitles them to file something in front of a judge and get a determination on whether they're qualified or not. We think there's about 23 individuals that are eligible. We also know that 6 of them have pending civil suits, and if their civil suits were to get settled, then those individuals would likely not be eligible for any kind of compensation under this statute. I also want to say on those numbers that Lori Roberts is here. She's the policy analyst from the National Innocence Project, and she gathers data from around the country as to what other states are doing and how their statutes are working in individual localities, and that on average about 60% of those that are eligible apply, and of those that apply, about 75% are successful in receiving an award under the compensation statutes. So if you crunch those numbers, it's about 45% of all individuals that might be eligible that ultimately receive compensation, and that would take us down to about 12 individuals in Kentucky out of the original 23. There's also a very important provision in there, and that's a civil offset provision, and that assures that somebody who does receive a civil settlement, if they're filing something with a private attorney and not going through the state compensation system, or if they've already received compensation, there's an offset, so that if they receive any amount of money that's in excess of what the state's compensation statute would supply, that they reimburse that money back to the state, or that if they have something that's pending with the state and they receive a civil settlement or win a civil suit, that then they will not receive compensation as long as that suit's in excess of the amount that's provided by the state. We welcome questions from the committee, and at this point, if there are any questions, we'd certainly like to talk more about the statute.
Mr. Chair, I want to highlight 2 things really quickly.
Sure, go ahead.
Number one, this is not a criminal justice reform bill. This is not a criminal justice reform bill, which leads into number 2. The persons who are eligible under lines 5, 6, and 18 and 20 of page 1, they have to prove actual innocence. It's not just that the constable has blundered. It's not just that they didn't get me, or they have to prove that they're innocent. And I think those are important things to focus on. Thank you, Mr. Chairman.
Thank you very much. Representative Rawlings.
Well, thank you, Chairman, for inviting these individuals in that have suffered through these examples. And it's so good to hear their compelling testimony, what this is really about, justice for all. We should be all concerned about justice for all. So I had a question on a court decision that states dismissed with prejudice. Representative Niemes, can you discuss that, how we overcome that, how we get these people compensation quicker, and what kind of obstacle that's going to be?
So are we talking about at the initial stage? Obviously, they will have been convicted, and they will have presumably gone through the appeal process.
Right.
Right. Later on, this is kind of like a habeas corpus or a 1983, akin to that. Not exactly, but akin to that, where they can, in that situation, collaterally attack the conviction. Here we're talking about, similar to that, you file a case, let's say you were convicted in Boone County 10 years ago, and you prove that somebody else has said, look, I did it all along, or maybe DNA evidence shows that you didn't do it, then you can file this case. That's what this allows in Boone Circuit Court, because that's where you were convicted, and show you have to show then actual innocence. So the fact that the first proceedings are concluded doesn't bar this. One thing that we do want, and maybe this might be an amendment, is when we file that case, the showing actual innocence in Boone County, when the judge makes a finding, then that obviously we want that to be with prejudice, because that's the end of the day.
Okay.
I don't know. I hope I'm answering your question.
Yeah, I just wondered how you overcome an earlier court decision and then innocence is proven. How do you overcome that decision with prejudice that they were guilty?
Well, we already allow that in our laws under habeas corpus proceedings section. Those types of. I said 1983. I'm not sure that's the right section, but habeas corpus proceedings. So I don't know if you want to.
Well, in addition to that, nobody is eligible under the statute unless they have actually been convicted. So anything that is dismissed at any point in time prior to a conviction, that there would be zero eligibility under the statute.
Okay.
Yeah, and hello, committee. My name is Lori Roberts. I'm with the National Innocence Project. Thanks for inviting me to speak. I also just want to emphasize that in a post-conviction setting, if your charges are dismissed with prejudice, that still means that you're still eligible based on the plain language of the law right now. It sounds like you're asking, should there be a slightly quicker process for folks who are have their case dismissed with prejudice in a post-conviction setting? Is that right?
Yeah. Yeah. Also, in that regard, is there an expedited process that they can have some card with them that deems that they're innocent, something they can show an employer?
Absolutely. So part of the law, if you are successful in demonstrating innocence and being granted compensation, one of the provisions in the law in HB 571 provides you a certificate of innocence, which you can then carry with you and use for those purposes.
And it does require, Representative, all of the records to be sealed and removed from any record the courts would have, or I suppose the Kentucky State Police, from the places that employers would look to on your background.
Okay, one more quick question.
Yeah, very quickly.
Social Security, they've lost how many years? 15, 20 years in Social Security, so when they retire, they don't have benefit level. Is there anything you can do about that?
That's correct, and we've seen many of our exonerees who experience that, especially if you're out of the workforce for 20 years during the prime of your earning years, that there's a reduction, or if any, Social Security. You don't earn Social Security when you're working in prison. You get, if you're lucky, $1 or $1.50 an hour, but there's just not enough Social Security being drawn out of there for them to get a payback when they're eligible.
If there is interest from this committee in coming up with solutions to address the lack of Social Security in the elder years, we would certainly be ready and willing to work with you on language for that.
Sounds like, no doubt about that. We did know, I wanted to note on page 3, we are allowing these persons to participate in the public employee health insurance program if they would like to. So that's part of what kind of getting to the interest that you're talking about, but we've not addressed, we can't address the Social Security directly. We can do it.
Yeah, well, I think that gives even more justification that we need to do this, because they're losing so much in the Social Security system.
The bill provides for some of the other areas of social support, such as financial literacy, medical insurance that would be provided by the state, which is really critical for some of our older exonerees, assistance finding housing, mental health counseling, an educational component, which would be consistent with like what you would see for juveniles, tuition remission, where they can go to a state school and get 4 years of education, as well as trying to help them find reliable transportation, social services.
Good, thank you.
Representative Decker.
Thank you. Thank you to the witnesses, all of them, and to you, Representative Nemes, for bringing this again this year. You all convinced me last year. Okay. But I have a question.
We may not answer because you said you already convinced.
It may be better.
I'm just kidding.
So, as I read the bill, this needs to be brought in a separate action after the case is dismissed, etc. I'm wondering, in the event of a hearing as anticipated in subsection 3 of section 1(2), where there's a hearing for reversal, dismissal, upon retrial, etc., could this bill be amended to allow such a claim at that time so as not to have to wait, not to have to bring another case, etc.
I
I know there's practical concerns about the dockets, etc., but could you amend the bill to allow it then so that someone wouldn't have to wait, come back?
I think that would be terrific, and actually it'd be good on the court's docket because we'd handle it then, not later. I think that would be a very good amendment. We'll call that the Representative Decker Amendment.
Thank you. Thank you.
Thank you, Representative Herron.
Thank you, Chairman. Thank you all for bringing this bill up. I am someone who fully supports this, and I have had the opportunity to follow Ms. Jonetta Carr's story. One of the questions that I have, or comment/question, is I know currently in Kentucky statute, we still allow juveniles to be questioned by law enforcement without parents and or before parent contact and before a legal representation is present. And so the first question I have is how many of the folks who have been exonerated were charged as juveniles? And then the second question is, Representative Nemes, is this, are you willing to also work on legislation to ensure that juveniles have that representation before they are being questioned by law enforcement?
I'll handle that one and then pass off the first question. I have 3 sons, and I don't want anybody talking to them on anything that might affect their liberty without my wife or me present. So I didn't realize that was still the law in Kentucky. Pardon my ignorance on that. But yeah, I certainly do not think my 17-year-old son should be questioned on something of that magnitude without me being present or my wife. Yes, I think we should, if that is, I presume that you're right. I think we should change that. The first question about with regard to how many juveniles were charged, I don't know the answer to that.
Larry Osborne was charged and convicted as a juvenile, and that was prior to the Roper decision that made it illegal to sentence juveniles to death. And he spent time on death row.
Yes,
His conviction was overturned.
we're aware of at least 3 juveniles who were charged and convicted before they became adults wrongfully.
Thank you all for that. I just would like to let this committee know that I will be working on legislation to change that in Kentucky, and look forward to potentially working with you on this, Representative Nemes.
Representative Dietz.
Thank you. I have 2 procedural questions. My world is in family law, and I represented a gentleman in that context. He also then was charged and then convicted of a crime, went to jail. He had an attorney working on his appeal. During that process, he was pardoned by the governor. How often does that really happen? Your client keeps saying, I'm going to get pardoned, I'm going to get pardoned. I'm like, yeah, right. He got pardoned by the governor. My understanding is that they still have to work through the appeal process then to finish that piece. So I'm wondering, how does that work then with subsection 3.3, where he did not commit the crime? So I'm just looking, is that a procedural, something we need to clean up so that if you're waiting on that appeal process to finish, even though they've been pardoned? Do you understand what I'm trying to say?
You've still been convicted. The judgment may not be final, but you still have a conviction. You're serving on that conviction. I believe that individual was in prison during the pending appeal. And so you're still eligible under the statute. And to some extent, depending on what happens after the pardon, the appeal actually may, depending on the contents of the pardon, the appeal may become moot. So you still would be eligible because you have a conviction. Whether or not the appeal has become final or the appeal is dismissed should not make any difference.
But I definitely agree with that. I do want to highlight, though, that there are a lot of people there are some people who get pardoned who are not necessarily pardoned because they're actually innocent. And so while that would be strong evidence, I think, in any proceeding, I want to hold the line on actual innocence. And just because you've been pardoned does not mean you're actually innocent. It is very good evidence of that. But I think Governor Bevin pardoned a lot of people who he thinks deserved it for other reasons, but not necessarily because they were innocent. I don't think those people should be eligible if they were guilty, but they were pardoned for other purposes.
And then, if I can, I just have one more question.
Yes, go ahead.
And that had to do with the child support. And maybe I'm just reading it wrong. That's on page 4 of 6.
it says that they would be relieved of their child support payments owed by the claimant that became due. But when you go to the last sentence, it says the amount owed shall be awarded to the other parent or guardian of the child. So my question is, who would be paying the child support? Is that something the state would pay back, or am I just misreading that?
Yeah, so that would be part of the award that the courts would award on top of the annual amount that you are eligible for, like other parts of the awards, such as reimbursement for court fees and fines.
All right,
And what we're trying to do there, obviously, is thread the needle. This person shouldn't have to. They should be reimbursed for any reimbursement they paid to the victim that they were not the perpetrator of, and also anything that they were anyway harmed, like child support. They shouldn't have to pay. However, this is the thread and the needle part. We want to make sure that that child and the other parent aren't harmed either. And so it's part of the paying for the window, if I might go back to my previous hypothetical. I also, so anyway, that's the answer.
All right, thank
but
you.
I know you're the expert in this. I'd love to have your thoughts on how we can better word this and make it work mechanically.
Okay, thank you.
Thank you very much, Representative Nemes, for the presentation. Thank your guests, and I also want to thank the witnesses who came forward to provide your testimony. And I'm at a loss for words, really, as to what I can say to you, but what comes to mind is I'm sorry for what happened to you. That's so we're going to move on to the third item.
Thank you, Mr. Chairman.
On our agenda. Non-recourse consumer legal funding, Representative Flannery. If you'd come forward and introduce your guests, and you may proceed. Thank you, sir. You may proceed.
Okay, I'm State Representative Patrick Flannery from the 96th District, and I will let the gentleman to my left and right introduce themselves.
I'm Eric Schul. I'm the president for the Alliance for Responsible Consumer Legal Funding Trade Association, represents the companies that offer this product.
Thank you, Mr. Chairman. I'm Mark Wilson. I'm a partner at Top Shelf Lobby here today advocating Mr. Schuller's group, and I think that Coach Stoops might be looking for us to work on his line this year, so football season's coming up.
It begs the question, any name, image, likeness legislation, Mr. Chairman, that could maybe help compensate us. But so what are we talking about today, and why is legislation necessary? So what is non-recourse consumer legal funding? Talking to even many lawyers, they may not be really familiar with this. So what is it? Very simply, we're talking about small balance transactions, typically about $2,000. That's the average, that are given from third parties to plaintiffs, typically in car wreck cases, but it could be other cases, to help bridge them until the case resolves. Why is it needed? We are dealing with really a unregulated space, completely unregulated, where there's no law governing this. My goal is to bring order to this chaos. I think it's absolutely needed. And we just have a wild, wild west system where there is can be bad actors that are taking advantage of people. They're doing whatever they want, whenever they want, however they want. And that's why I believe that this concept that I'm trying to put forth is needed. A lot of other states are tackling this issue. I'd like to list three what I would call misconceptions or falsities that I typically hear on this topic that I think it's important to discuss. Number one is that these transactions are currently unlawful. That is not the case. These transactions do occur in Kentucky. And as I said before, they're completely unregulated, no laws governing them. I think that we need to enact some sensible consumer protections on these. Number two is that this legislation will or could lead to more litigation. I don't see how this legislation would do that because it's already happening. So it's not going to cause more litigation. And we're going to have the same amount. I don't see how this legislation would change that. And 3, I think this is really important because I have found that often the opponents to this, sometimes from the business community, get this mixed up, and there's a lot of maybe misuse of terminology and different uses of certain terminology, but it gets mixed up with what I would call litigation financing, which is somewhat of a related topic, but it's not really what I'm trying to address. Litigation financing is typically where you have big moneyed outfits that will actually help finance litigation that they see maybe potentially being non-figure type lawsuits against corporate giants and whatever, kind of if you want to think of an Aaron Brockovich type situation where you've got huge judgments. We're not talking about a small town car wreck case with, someone that, is just trying to get a case resolved. So, and I just feel like those terms get intermingled and misused, and that's not what I'm talking about here. So kind to go back over, just emphasize again, we're dealing with a completely unregulated space. I think this legislation is important. The concept of what I'm trying to do, the goal is to put some guardrails up. It can be, some say it's usury. I wouldn't say that they're wrong in looking at some of these transactions, but wanting to place some cap interest rates. 3, I think it's really important to emphasize what non-recourse means. That means that the person that is even though technically this is not a loan, but the person or organization that's lending the money, if the case is not successfully resolved, they're not getting paid back. So that's important to state. And 4, there has to be an active suit, which is typically what I find in these transactions right now. As I stated before, the average transaction on these types of cases, which I think Mr. Schuler may be better discussing, is typically around $2,000 from talking to other practitioners. That seems about right. And what these plaintiffs, what these consumers have to typically pay back, on a $2,000 transaction, oftentimes can be $4,000 or $5,000. And I think these people are being preyed upon, and we need to enact legislation to protect them. Mr. Schuler is with a trade organization that is involved in these transactions, and I believe he has a slideshow that will address some of these issues.
Thank you, Representative. As again, my name is Eric Schuler. I'm the president for the Alliance for Responsible Consumer Legal Funding. And as I said, we're the trade association that represents the companies that offer this product. This is kind of a brief description of what consumer legal funding is. It provides a financial tool for a consumer that has a pending legal claim. As Representative said, our average funding is about $2,000, and typically we fund no more than about 5 to 10% of what we think the expected value of the claim is. So we're not going to give someone all kinds of money because it's not in their best interest, and it's also lowers the possibility of having a recovery on the product. As I said, it's a non-recourse product, meaning that if the case doesn't settle, there isn't a settlement, or even in the rare instance that does happen where the client does drop the case, the consumer owes us nothing. There's no recourse against them, meaning that the company cannot ding their credit, they cannot sue them, they cannot garnish their wages. They're just simply out the money. The company is just simply out the money. So this is kind of the only financial product out there that I know of that you only have to meet your obligation if someone else gives you money. If that third party does not give you money, you do not have to meet your obligation. It's totally different than any other financial product out there I know of where it's a car loan or a mortgage or whatever it is. The person that's providing you with that financing doesn't care where you get your money from. They just want their money. We care where you get your money from, and it has to be from the settlement and enough funds from the settlement in order to make this happen. It's basically how it works. The consumer contacts the company then verifies the information that the consumer has. They go over the case with it. Meaning, when I verify the information, they'll also talk to the consumer's attorney. Because, of course, we know consumers never exaggerate what their claim is worth. So they want to talk to their attorney to make sure that the information is correct. They'll review it internally Most companies have former personal injury attorneys or claims adjusters that work for them. They'll look at the case and say, okay, based on our experience, your case should settle for X. We're going to give you Y. At that time, then you contact the consumer and say, this is what we're looking to provide you. And we also contact the consumer's attorney to make sure the consumer's attorney is comfortable with the amount of money that we're providing with their client. If that consumer's attorney is not comfortable with that dollar amount, it does not happen. So their attorney has to be comfortable with the amount of money that we're funding their client. Once that's both done and executed, then the funding is then provided to the consumer. Kind of why we're here, what as representatives, and makes this ambiguous. There's a case with a company, Prospect Funding Holdings. Long and the short of it is, there's a saying of pigs get fat, hogs get slaughtered. Prospect was a hog. They charged very high rates on the product and were just not a good party in the space. And the judge in the case basically said that these contracts need to be brought in line. What's interesting is the legislation that we're talking about today, if this had been in place then, that case never would have happened. Prospect would never have been able to do what they did in the case. So what we're trying to do is bring clarity to the situation where right now there's ambiguity. This is kind of where the regulation of the industry is. I can see just about everybody around around Kentucky, with Missouri just passed it, so that should be green as well, has passed legislation except for Virginia. This is kind of what we're looking at for what the bill would look like and what we're introducing. Clear language for the consumer, acknowledgement by the consumer's attorney. These are all, and I want to go through and read what you can see for yourself, but these are all steps that our companies already agreed to in best practices. What we want to do is codify them and put them into statute, demanding that everybody that does offer this product do this as all our companies do already instead of best practices. Finally, prohibited acts. No commercials, no quid pro quo back and forth, no making false claims, not offering to pay for any legal fees or court costs. So as the representative stated, there's another facet out there called litigation financing, which actually funds the cases. We're prohibiting that in this statute. The money that we provide the consumer cannot be used to further litigation. It can only be used for household needs. And an attorney who represents the consumer cannot have a final interest in the funding company, meaning that there cannot be any backdoor deals going on with this. All fees should stop at 42 months, written acknowledgement by the consumer's attorney, and full disclosure of the terms and conditions of the agreement. We don't want anything hidden here. We want to make sure the consumer and their attorney are fully aware of the transaction and fully aware of the terms and conditions of the transaction. I'll be happy to answer any questions you may have.
Thank you very much, Mr. Wilson. I don't know if you want to add anything.
Mr. Chairman, all I would just add to it is this is no stranger to this committee, and this will be the third session that we have run this legislation. Representative Blanton was the initial sponsor, Representative Flannery. We have several senators willing to advocate for it as well, and I think it's just important to note, I think Representative Flannery and Mr. Schuller have said everything that needs to be said, but except for the fact that we're just trying to put up some guardrails on a product that is currently being used in Kentucky with no consumer protections whatsoever. So that's what we're trying to attempt to do today and here and with this piece of legislation. So with that, we'll field your questions. Thank you, Mr. Chairman.
Thank you. We have Sherman Joyce on Zoom, is that right? Who is with the American Tort Reform Association. I wanted to give him an opportunity to address the committee, and then we'll go to any discussion that we have.
Mr. Chairman, thank you very much, Chairman Elliott and members of the interim joint committee. As the chairman mentioned, my name is Sherman Joyce. I'm president of the American Tort Reform Association in Washington, D.C. And I want to thank you for the opportunity to testify on legislative proposals to legalize non-recourse legal funding. My organization, the American Tort Reform Association, has significant concerns about these loans, which courts in your state have found to be in violation of Kentucky law prohibiting champerty, as well as the statutory limit on the interest rate that lenders can charge. We believe that legalizing such loans in exchange for a licensing agreement and what we believe are, quite frankly, inadequate regulations would benefit virtually no one other than these lenders. You heard a little bit of discussion about this business, but the model essentially is for these lenders to offer cash to people who have suffered an injury in exchange for a portion of a future settlement. These lenders do not consider these so-called payments to be loans because they only get paid, as you heard, if in fact there is a settlement or judgment, as is the case with a lawyer operating on a contingency fee basis. From the standpoint of a consumer receiving a small loan, however, as time passes, the extraordinarily high payday lending type rates these lenders routinely charge can take up much, if not all, of a settlement. And it's apparent to us, at least, that there is little true risk in most of these cases. You heard the discussion about how they are evaluated. No doubt the lenders undertake extensive review of these matters, and whether it's a routine case such as a fender bender, a slip and fall, or other actions, much the same way that contingency fee lawyers do. No doubt they also choose cases with a high probability of success, either through a settlement or verdict. They have no incentive, obviously, to do otherwise. From the standpoint of the civil justice system, we believe that lawsuit loans complicate the prospect for resolving lawsuits outside of court. I think it really, quite frankly, defies logic and common sense to suggest otherwise. Once presented with a potential settlement offer, a plaintiff who has taken out such a loan has to include the interest rate charged by the lender as a cost that he or she will have to bear along with the fees paid to that individual's lawyer. And these lenders have been known to charge as much as 4.99% per month. On an annual basis, that reaches nearly 79%. And it's clear that these fees plainly drive up settlement demands and reduce the prospect for resolution without the time and expense involved in full-blown litigation. One of the things that I would add is that we do not allege or suggest that these types of lawsuits spur frivolous litigation. But for those who believe that lawsuit lending is needed to promote access to justice, we believe that the important policy issue there is that contingency fees exist for that very reason, to ensure that individuals can hire someone to represent them. But I think you heard mentioned briefly about the bowling litigation and the matter that Mr. Schuler highlighted. Let's look at some of the details in that particular case. Mr. Christopher Bowling, a Kentucky resident, was seriously injured in 2009 after a gas can ignited, resulting in serious injuries to Mr. Bowling. He then took out 4 lawsuits that totaled $30,000 at a rate of 4.99% per month. When the case settled 5 years later, the balance on his loans was in excess of $340,000. This is more than 11 times the amount he had borrowed, and a significant, no doubt, a significant portion of the settlement that was intended to compensate him for the treatment of his severe injuries. But fortunately for Mr. Bowling, the U.S. District Court for the Western District of Columbia, District of Kentucky, District of Columbia is where I am right now, held that the lawsuit loans he entered into violated Kentucky law and were therefore unenforceable. A unanimous panel of the U.S. Court of Appeals for the Sixth Circuit upheld that decision on appeal. And according to the Sixth Circuit, lawsuit lending violated the state's statutory provision of what's referred to as champerty, which prohibits third parties, which in more simple parlance, any individual or entity other than the actual parties to a lawsuit, from having a financial interest in a case. The court found that the statute at issue reflects the strong public policy against assignments that can compel a party to prosecute a claim he or she no longer wishes to continue to prosecute, and complicates the ability to settle cases. It should be noted also that the court ruled that that the loans violated the state's law prohibiting excessive interest rates. The Sixth Circuit furthermore found, and I think this is particularly important, that what the lenders refer to as a quote unquote non-recourse investment or a loan is irrelevant, because the consumer protection provided by under the consumer protection provided under the state's usury statute. The court, I think this is the important point, looked to the substance of the arrangement, not its characterization or the label provided to it by the lender. Fortunately for Mr. Bowling, there was after all this litigation a better outcome. He ultimately owed lenders for the principal amount of the loans and the lender's costs, and that totaled $34,625. But his case demonstrates that the laws now on the books in your state provide significant protection to consumers in Kentucky. This past session, we followed legislation to exempt lawsuit lending from Kentucky's statutes on champerty and usury, both of which we believe, as the case I just discussed demonstrate, protect your consumers. In exchange for interest rates as high as 36%, lenders would be subject to some regulation and be required to secure a license. The bottom line from our perspective, however, is the enactment of such a proposal will allow lawsuit loans to flourish in your state. For the reasons that I've just discussed, however, we believe that this legislation, such as HB 224, is misguided. However, if the legislature does choose to move forward, if there is an interest in considering these issues, we believe there are two particularly important points. Number one, we believe that any lawsuit loan should be subject to a state's usury statute, and that such agreements also, this is the second point, must automatically be disclosed in litigation so that all parties and the court are aware of what is in fact an important external factor that can impact the ability of parties to reach a settlement. So for those reasons, we encourage you to maintain the status quo. We believe your consumers are well protected, and we believe that the case law with Mr. Bowling's litigation is the best protection for consumers. And I'm happy to answer any questions that you might have. And thank you again for the opportunity.
Thank you, Mr. Joyce. I know Representative Flannery has another meeting at 1. Is there any brief response that you would like to give? And then we have 3 members with some questions.
Yes, very briefly. I think the Bowling facts are substantially different than what we are typically seeing. As I stated in my initial testimony on this, these transactions are still happening. And I think that it's inaccurate to say that somehow this case is preventing it, that it's black letter law. We are dealing with just a completely unregulated space. As to, I guess what I would say kind of rhetorically or just as a statement, if this legislation or the concept, some version of it wouldn't pass, what are we really accomplishing? We're still allowing these transactions to take place that, and we're going to have to grapple, and consumers are going to have to deal with really no limits, no caps as to what these folks can charge them. So that's what I'm trying to do, is put up some guardrails. He brought up an issue as far as disclosure. That is a topic that seems to come up in this. I'm welcome to any conversation with any groups opposing this, that if they want to talk about that. What I would say is that typically on evidentiary issues such as that, if that was requested in the course of litigation through interrogatories or some sort of discovery request, typically in Kentucky, evidentiary issues, the Supreme Court says is the purview of the court. So I don't know if we could legislatively do that, but I'm open to any conversation. My hope is that we do something to put some guardrails up to protect consumers and not have a wild, wild west system of people charging whatever they want, whenever they want.
Representative Sharp.
Thank you, Mr. Chair. I've got basically two questions here. One, I guess, is clarification. Thank you, gentlemen, for coming today. Am I to understand there are no caps currently on these type of loans?
They're not. It's completely unregulated.
Okay. This kind of, to me, sounds like a payday loan type of situation. Can you address that?
I've heard those comments before. I can appreciate some similarities. What I guess would say the biggest difference is payday loans are heavily regulated, because I think as a matter of public policy, people, lawmakers, have understood that we need to put up some guardrails and put in certain limitations on what can happen in those types of transactions. I believe that's all covered by KRS 286 as a non-traditional, non-depository type transaction. So I would say that's the biggest difference. Is I can appreciate the similarities to some degree, but those transactions are heavily regulated. Every transaction is monitored, in fact, by the Department of Financial Institutions.
If I may, Representative, real quick, in order to get a payday loan, you have to have a job. A lot of times the consumers that we're dealing with don't have a job at that time because of their accident or because of their situation. So they wouldn't even qualify for payday. And also in a lot of other states where this product is available, we have a lot of consumers coming to us to get a consumer legal funding to pay off the payday loan. Because remember, in payday, no matter what happens, every 2 weeks, every month, you've got to make a payment. If you don't make a payment, that interest rate starts to build up. In our situation, you do not have to make any payments along the way until your case settles, and then only if your case settles. So there's a huge difference between this product and payday. In fact, if you're interested, there actually was a study done by Vanderbilt University by a professor there that did a good deep down comparison between payday and this product, and then determine that they're not one and the same at all. I'd be happy to get you a copy of that if you like.
Yes, I'd like that. Thank you, sir, and thank you for being here today.
Thank you.
Could I just chime in though, because one of the points I think that that Mr. Schuler made in his PowerPoint was he highlighted, and I think the representative talked about the need for a cap. It is interesting that he mentioned, Mr. Schuler mentioned Indiana. Indiana has a 36% interest rate in terms of the cap that under its statute, plus 7% annual service fee. And since there was a discussion about some of your neighboring states, I think it's worth looking at the fact that at least West Virginia has an 18% usury rate as a model, and we've also seen rates of 15% or 6% above prime. So I think there are different ways to measure what the appropriate interest rate might be if you're going to look in that direction.
Real quickly, if I may, the bill that we have here duplicates the rates in Indiana, and the interest rate in West Virginia is 18%. No one operates there because it can't make any money.
Representative Banta.
Yes, where I live in Northern Kentucky came the NKY Tribune came out with a pretty scathing article, and I was just wondering if you read it and if you can give us any information about that.
Yeah, no, I appreciate that. The report was done by a gentleman named Kevin Moore, and he used a study from Marathon Strategies. And according to the report, they're talking about nuclear verdicts and how third-party litigation financing increases nuclear verdicts. I went through and read the study. In fact, I have a copy here if anybody would like a copy. It's quite in-depth. But what's interesting in the study is Kentucky has only had one nuclear verdict in the last 3 years, which is currently, my understanding, is up on appeal. But I also find, which is also interesting, is if this product encourages nuclear verdicts, they also, in the report that stated, in Maine, Vermont, Indiana, Oklahoma, Nebraska, and Utah, since we have statute of consumer legal funding, there have been no nuclear verdicts on this books. And in fact, I reached out directly to the to the article author, Kevin Moore, and I asked him, I says, are you looking at doing this as for consumer legal funding or litigation financing? And I'll read you exactly what he sent me back. He says, Eric, I'm not an expert in the field of third-party litigation funding, but the outside looking in, I feel it is safe to say that there is an indirect or direct correlation that could be assumed. There are a lot of variables that have caused nuclear verdicts and continue to rise. And one of them is well-funded legal team. Just my opinion. The attached is a PDF from the GAO report. So what he's talking about is funding of the litigation. That's not what we're doing here.
Thank you. So we have 5 minutes, and we'll divide that between Representative Nemes and Representative Bray. So, Representative Nemes.
I'll be really quickly. Thank you, Representative Flanders, for bringing the bill. I understand that there may be some provisions that we can tweak and improve, but I want to note that right now it's unlicensed, unregulated, unlimited. You could possibly bring a lawsuit like Mr. Bowling did. Mr. Bowling was a lawyer, by the way. He knew what he was getting into when he signed it. But okay, so what this does is it licenses. So anybody offering this product will have to be licensed in Kentucky, and it limits what they can offer. This is just a freedom question to me. And I mean, we know why people are against these. I mean, let's just say it straight, right? I'm a lawyer. If I'm representing the defendant, I want as much pressure as possible on the plaintiff to settle. There's no doubt about it. If I'm a plaintiff, I want as much pressure as possible for the defendant to settle. So this is and we're not talking about these $1 million loans. What we're talking about in the cases that I've been involved in, and I don't do plaintiff's law anymore, but we're talking about like a $2,000 loan so somebody can pay their rent. We're talking about something they can get some transportation. That's what we're talking about. We're not talking about these huge to fund these huge litigations. And let's just say it straight, and let's be honest. We know why people are against it, and there's nothing dishonorable about that. You know, as a lawyer, when I represent defendants, you're darn right I want to put as much pressure on the plaintiff to settle as I can. But as a legislator, we have to do what's right for looking at all interests. And it's clear that what's going on today is not right. These people are being preyed upon. It's also not right to get rid of them altogether. This is an asset that they have that they should be able to market in a free marketplace. That's what this is. And so like we do payday loans, and look, I don't like payday loans, but some people get payday loans to pay immediate things that they need. And what this will do is it would enable somebody to pay for something, and we're limiting how much that the person loaning them can charge. I don't see much problems with this. Let's talk about tweaking at the edges, but let's not talk around this issue. We know why people are against this bill. It's as simple. It's good people are against the bill, but we know why. As legislators, the right thing for us to do, it seems to me, is to tell our friends no sometimes, and this is one of those situations.
Representative Bray.
Thank you, Mr. Chairman. So within the bill, the interest rates are capped at 36%, as I understand. Is that correct?
Yes.
Now, if I take out a $2,000 loan for transportation when my lawsuit starts, does that interest build up all throughout my lawsuit that could take years to settle, so that I'm paying 36% on $2,000 in year one, then 36% in year two, but I don't have to pay for it, but my debt is accumulating as the lawsuit goes on, correct?
That's correct, but we stop all fees at 42 months. So if the case goes past 3.5 years, it stops at that point.
So over 3.5 years, I paid 90% interest then.
If you look at it cumulative, if you use those same numbers as well, if someone gets a home mortgage at 30 years at 7%, they're paying 117% interest.
But I'm making payments.
But you're
as
making
I go
payments
along
the way. Here, we're not making payments. But also, too, if your case doesn't settle or you lose your case, you have no future obligation to that company. You actually keep the money. You actually if your case goes south, you actually gain more than the attorney does, because the attorney takes on a contingency basis. So you're actually making more money than the attorney did, because you got money up front on the case.
But we're talking about $2,000.
You're still making more money than your attorney if the case goes south, because the attorney's coming away with zero. He takes it totally on contingency.
Are the loan amounts capped within the bill?
Typically what we do is no more than about 10% of what we think the funded amount is. So we're dealing in majority of the time here car accidents, which are $20,000 to $50,000 types cases.
So, but is it capped within the bill? I mean, you say it's usually like $2,000. So are we like capping this, because payday loans are capped? Is it capped in this? I mean, are we talking?
Not currently, but it's it's a type of situation that we don't think it's really needed, because it's not really done. I'll be honest, there are occasions when someone is needing $30,000, $40,000, $50,000, But those are extreme cases, and typically those are cases where someone has an amputation, they need to have their house rehabbed, or needs home health care while their case is pending. Those are extremes, and I think we need to have some variable to allow those to happen.
If we're protecting the consumer, why wouldn't we cap that in this?
Well, you have to remember too, their attorney is signing off on these transactions as well. So if their attorney doesn't think this is in the best interest of their client, they're not going to sign off on that transaction. That's something I'm happy to discuss with.
And I would like to add to that. I think the second part, that is a good question. These are non-recourse. So the person's offering the money don't really want to be involved in a bad transaction. Okay, so to some degree, they use good business judgment, and they're not throwing out money that they feel like they're not going to get back. And I think typically that's why you see smaller balances around an average of $2,000, because they feel like that's a working balance. But hope that addresses that. I would say, Mr. Chairman, I've got a 1 o'clock committee meeting, so.
And you're right, we've reached 1 o'clock, so that's the end of our meeting. Thank you, gentlemen, very much, and the committee will stand adjourned.